I'm here with Mr. Danny Easterling, who's going to talk to us about his most recent not guilty by reason of insanity case and give us a little bit of tips about how to voir dire a jury on that. Could you go ahead and introduce yourself?
Hi, I'm Danny Easterling. I practice law here in Houston, Texas. I've done so about 35 years, and I'm board certified in criminal law.
Could you tell us a little bit about your most recent not guilty by reason of insanity case?
Basic facts were I represented a client who was in his late 40s. He lived with his father, who was 83 years old. He was an elderly fella. And during a very severe psychotic delusional episode, he stabbed and killed his father. He had the delusion that his father was going to shoot him with the shotgun that was in the house. But of course that was a delusion. So that's the basic facts.
Could you tell us a little bit about your approach to voir diring your panel? How did you get them on board with an insanity defense? How did you talk to them about insanity and explain the law to them during your voir dire?
It's important to educate and warm the jury panel up to the issues of mental illness and particularly the insanity defense. Jurors come in off of the street with a very high degree of skepticism and suspicion about mental illness and particularly about the insanity defense. I think they have this feeling that it's a crutch or it's an excuse or it's some sort of way to avoid responsibility. And they learn this from the media and from movies and from other experiences they have in life. So it's important to educate them about the law and let them know that these things actually happen, that mental illness is real, and that you got to get them feeling some compassion and some understanding about it, and you get them talking about it.
How did you get them to talk about it while you were picking your jury?
I let them know that in Texas and most states, I believe, it's an affirmative defense. You have to prove two elements. The defense does by a preponderance of the evidence. The first element is usually a given. It's not that difficult to prove, and that is that your client is suffering from a severe mental disease. The second element is the one that is fought over the most in any jury trial where there's an insanity defense, and that is we have to prove that because of that severe mental disease, that at the time he committed the crime, he did not know his conduct was wrong. That's where jurors have a difficult time deciding that element. But it is important to let them know that this is an affirmative defense, and fortunately our burden of proof on the defense side is much less than the government's burden of proof. A preponderance of the evidence is what the burden of proof is on this defense. And as we know, that's the civil burden. It's lower. It's defined for the jury as the greater weight and degree of the credible evidence. It's only 51% or more. So you educate the jury and you pound home to them that if I have the greater degree and more of the evidence on my side on the insanity defense that's credible and believable, then you have to find the defendant not guilty by reason of insanity. So fortunately, the burden of proof is less.
This veneer panel, what got them talking? So what did you say to them to get them to speak about insanity so that you could gauge their ideas about it?
Well, you have to make sure that the case is going to be about intent, intent, intent. Everything about the case is going to be focused on the intent of the defendant. You let them know all that up front. You have to concede certain things, and usually they'll start getting the message pretty quick that he must have done this. We're going to be deciding why he did it and how he did it and what was going on in his mind when he did it. So it's important to go through these concepts with them. I like to get them talking about mental illness and ask them if anybody in their family suffers from mental illness or any close friends, and get them talking about how frustrating mental illness can be and just how strange it is whenever the brain dysfunction has a dysfunctional nature. And the other jurors can start hearing about it firsthand from their other fellow jurors. The other thing I like to do is I like to ask them to speak about, what have you heard about some of the most famous cases of insanity? In Houston, we had the Andrea Yates case where she drowned her and killed her 5 children. Most everybody remembers that, so I get them talking about that. And then I get them to answer what happened to her. And of course, most of them will say, well, she went on to a state hospital.
What tips do you have for attorneys who are going into an insanity defense case?
I think it's crucial to investigate thoroughly your client's mental health history. You got to look at all the records, all the hospitalizations, all of the evaluations, and it's important to highlight those because a lot of times you'll have thousands of pages if it's something that's gone on for a long time. And it's important to highlight the most severe incidents that can convey just how seriously mentally ill your client is. So I did that in this case. I highlighted all of the suicide attempt, the severe depression, highlighted all those things so that it was easy for me to explain those to the jury rather than just dumping down a box of records. Important to do that. And of course, you work closely with your own mental health expert. In my case, it was a psychiatrist who did a very good job. So you have to obviously learn as much as you can about your client's history and be able to convey that to the jury in a credible way.
What feedback did you get from your jurors about your voir dire, and what's the one thing that you wish you could have told the jury or the panel before you got them in the box?
Well, during deliberation, the first question out of the jury room was, if we find the defendant not guilty by reason of insanity, what happens to him? Does he go to a secure mental hospital? In Texas, the law is very frustrating because we can't tell the jury what happens to somebody if they're found not guilty by reason of insanity. And so we can't tell them. And they want to know that. So that's a frustrating thing. And that's why I bring up the famous cases like Andrea Yates and voir dire, because I ask them what happened to her, and they'll say she went to a mental hospital, and then you hope you've thrown the hint to them, yeah, that's what happens to them. So that note came out, and sure enough, they wanted to know immediately when we went back there to talk to him after the verdict, is that where he's going? And we told them yes, and they were relieved that that's where he was going to go and be treated. And they all universally agreed with me that the law needs to be changed in Texas where they can be informed of what happens to somebody and that they know, the jury gets to know where they're going, and they'll be under jurisdiction for life of the court, and usually most of the time they never get out. The last thing that was confirmed is the suspicious nature and the skepticism of jurors about the insanity defense. One of the jurors actually told me after the trial is, well, you know, Mr. Easterling, whenever you were bringing up the insanity defense the first day and during jury selection, I was going, yeah. But every day you kept bringing more and more evidence, and it all added up at the end. So it was a very interesting discussion with the jurors, but they were relieved that he was going to get some treatment and he wasn't just going to be let out on the street.
Thank you very much for your time, and these were very informative answers, and hopefully everyone will pick them up when they're trying their next insanity case.
Thank you. Good luck to everybody.